皆様、こんにちは。本日は、アジアフォーカスニュースレタービデオストリーミングの第2弾ということで、ベトナムの知的財産法改正について、その概要をお話しいたします。私は、コーポレート、ベーカンド・マッケンジーコーポレート M&A 部門のパートナー、富本と申します。私は現在シンガポールオフィスに出向しておりまして、アジアジャパンデスクという名称で、シンガポールおよび東南アジアに所在する日本企業のお手伝いをさせていただいております。ベトナムの知的財産法改正は、ベトナムでビジネスを行う日本企業にとっても非常に重要なトピックですので、皆様にその概要をお届けしたいと思っております。本日は東京オフィスの知的財産部門のパートナー竹中陽介とハノイオフィスのHoaトランとともに内容をお届けいたします。それでは英語にスイッチしてご説明を始めようと思います。So Hoa, I will now switch to English and start with my question. So the Vietnamese amended IP law was passed in June 2022 and has just come into effect on January 1st of 2023. My first question is, what are the important changes to the amended IP law?
So the amended IP law amended and supplemented 102 articles of IP law. In particular, the amended IP law amended 88 existing articles, added 14 new articles, and announced 2 articles. These amendments align with the government's policy for developing and protecting IP rights as well as its efforts to comply with Vietnam's international commitments. So let's talk about some of the major changes under the amended IP law. The amended IP law provides more detail on regulation concerning the identification of holders of access rights, which could facilitate the transfer of ownership and licensing of copyrights and related rights. The amended IP law allows the transfer of some borrow rights. It also grants presiding organizations the right to register intellectual property access, such as patents, industrial designs, design for semiconducting closed circuit, and plant variety, created using the state budget to encourage the creation, exploitation, and dissemination of IP access. Further, it simplifies the regulation on procedure, time limits, dodges concerning the registration of IP rights, making them more convenient and transparent. In addition, it introduced regulations on the protection and enforcement of IP rights to ensure proper balance between the benefits of rights holders and the public's right to use and access social knowledge and technology, which will improve overall right protection. So the amended IP law also provides regulation on industrial property representation and assessment services with a view to facilitating IP support services. We now have also amended and supplemented regulation on technological measures for rights protection and information management, as well as the exception for copyrights and related rights to better comply with international commitments. Finally, the amended IP law amends and supplements the regulation on sound marks, invalidation of trademark registration, and the obligations to protect the test data for agrochemicals, not to mention the obligation to proactively suspend the custom procedure related to alleged infringing products and others.
Thank you for your explanation, Hoa. My second question here is the amended IP law contains a long set of changes to IP objects, including trademarks, In your opinion, what changes in trademark regulations and practice may have a significant impact on how IP rights holders manage their portfolios and conduct business in Vietnam?
So, well, I would say that certain trademark regulations have been revised under the amended IP law, which also welcome some new regulation in this regard. In my opinion, there are four key changes in trademark regulation and practice. First, we now have a revised definition of well-known trademarks. Instead of the old and generic definition of widely known by consumers throughout the territory in Vietnam, we now define a well-known trademark as something that is widely known by the relevant sector of the public in the territory of Vietnam. This new definition is more consistent with international standards. It also means that trademark owners have better chances of having their marks recognized as well-known marks in Vietnam. Second, I would like to highlight a key development. The adoption of sound mark protection for the very first time. Sound marks have been to the list of sites that are eligible for trademark protection, and it fulfills Vietnam's commitment under the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, CPTPP for short. Until now, there have been no guiding decrees or examination guidelines regarding sound mark protection. We are keeping an eye on this situation, and we will be happy to share more information with you as soon as the sources become available. The third thing about the third major change had to do with the statutory deadline for trademark opposition and also a new parallel mechanism for third-party opinions. For the official opposition procedures, there is no specific opposition deadline under the existing law, and this causes some delay in the trademark examination procedure because opposition can be filed at any time before a trademark registration is granted. With the amended IP law, the opposition deadline is shorter and stricter, and a fixed procedure are in place. Specifically, the opposition deadline will be within 5 months from the publication date of the application. A new parallel mechanism for third-party opinions are also adopted. This procedure has no deadline, which means that any written opinion can be filed at any time after the trademark is public and until the trademark is granted protection. However, these written opinions only serve as references for examination. This means the trademark office is not required to handle or respond to such written opinions. So last but not least, bad faith is now an official ground for trademark oppositions and invalidations. In other words, bad faith will be now organized as a legal ground for opposing a trademark application or for invalidating a trademark registration. For the longest time, the lack of bad faith grounds has made it difficult for trademark holders, especially those without trademark registration in Vietnam, to file trademark squatters.
はい、エーカンド・マッケンジー法律事務所、IP テックチームパートナーの竹中でございます。ベトナムの今回の改正は今説明をしてくれた商標法以外にも他にもいろいろと重要なものがございまして、その一つがインターネットサービスプロバイダーに関してのコピーライト著作権侵害に関しての新しい規制がございます。このあたりについてHoaさんに少し詳しく説明をしてもらいたいと思います。So Hoa, in addition to the trademark issues, I think that the new amended IP laws covers new obligations of internet service providers regarding the copyright infringement. Could you please explain these new regulations for us?
So one of the key supplements of the amended IP law is Article 198B, which provides a general framework for the legal liabilities of Internet Service Providers, ISP for short, concerning copyright and related rights. In particular, ISP will be responsible for, first, deploying technical measures. Second, coordinating with the competent state agency and rights holder in enforcing copyright protection measures on the Internet and telecommunication network. So ISP are exempt from legal liability for infringement of copyright and all related rights on the Internet and telecommunication network when their services are used or provided in certain circumstances. For instance, as mere conduit, ISP only transmit digital information content or provide the ability to access that digital information content. So when it comes to caching, ISP transmit temporarily stored data, intermediary stored data, and automatically stored data that user posted or provided on the telecommunication networks and the public internet. This makes transmission to other users more efficient and enable ISP to meet specific technical conditions. As for hosting, ISP can store content upon user's request as long as the ISP do not know that the host copyright infringing content and promptly remove or block access to content as soon as they discover that the content infringe copyright. So in earlier October last year, the Copyright Office of Vietnam, COV for short, which is under the Ministry of Culture, Sports and Tourism, MCSD for short, held a conference with the stakeholders to introduce a draft decree that provided details on several articles of amended IP law on copyright and related rights. We call draft copyright decree for short. To guide and implement Article 198B of the amended IP law, the draft copyright decree inherited some requirements from Joint Circular Number 7, which was jointly issued by the MCSD and MIC. The Joint Circular Number 7 stipulates the responsibility of ISP to protect copyright and related rights on the Internet and telecommunication networks. More recently, in late December last year, the COV held a workshop in Ho Chi Minh City to get the opinions of key stakeholders on the takedown mechanism for copyright infringing content under the draft copyright decree. According to the COV, the government might approve the finalized draft copyright decree soon. So the decree will take effect immediately, except for the obligation applicable to ISP, which will take effect on the 1st July this year.
Thank you very much. 今回の、知的財産権の、改正に関してはかなり、重要なものが多く含まれておりますが、一般的に我々日本企業が何を注意をして知的財産権の保護の活動を行っていけばよいのかについて一般的なアドバイスをHoaさんからもらいたいと思います。So Hoa, I think that the amendments of the IP laws in Vietnam is kind of very important and significant. So could you please give us your advice and guidance how to effectively protect our clients' intellectual properties in Vietnam under the new IP laws?
So given all the major changes under the amended IP law, I would encourage the rights holder to consider some major issues such as brand management and enforcement. First, I believe brand owners should audit their brand portfolio to identify potential risks and ensure they are managing their portfolio effectively. Now, as discussed, the amended IP law contains revised and new regulation on trademark examination and disputes, so a portfolio audit may be very helpful in identifying trademark protection gaps and providing you with better tools for challenging any potential infringement. Second, be ready to file sound marks, if any, to claim priority rights, because Vietnam follows the first to file principle. Third, you should update your trademark watch service, or docketing system to reflect the new opposition deadline in Vietnam when the amended IP law went into effect. One more point, I thought that you revisit the brand enforcement strategy to keep up with the revised regulation and local practice for trademark enforcement actions, such as administrative and custom measures, to name a few. So speaking of copyright, again, because of the new and revised copyright regulations, such as I believe that it is critical to obtain relevant legal updates and advice when conducting any business activity that involve copyright issues under the amended IP law took effect. This will help protect your business from unexpected challenges. The new revised and regulation had to do with, first is exception to copyright infringement, enforcement against infringement, right to self-protection, and the responsibility of ISP, to name a few. So Vietnamese government has been working with the relevant authorities to issue the necessary decrees and guide the law's implementation, including a decree on copyright and related rights, as mentioned earlier. We are happy to keep you updated and assist you in any way possible. Thank you.
はい、ということで、今回は、コピーライト、それと商標法、その他にも、ベトナムにおいて新しい、知的財産権の改正がございまして、実務的にもかなり影響のあるところが多かったかと思います。ベトナムで実務をなさる方におかれましては、この点を、検討いただきまして、新しく、ビジネスをしていただければと思います。本日はご視聴いただきまして、誠にありがとうございました。